Hey everybody, hope you're all doing well. You might have heard about this controversial story in the news lately, where an Ontario judge is presiding over a criminal case, and he's doing it remotely while suspectedly vacationing in Barbados, in the Caribbean. The defense lawyer in this case, Leo Kinahan, has said that this is a situation where a judge while vacationing could potentially be sending his client to jail, and he has called this completely and totally offensive to the administration of justice. Apparently, in December of 2020, the judge convicted the accused, also in a remotely held trial, but at that time the judge was still in Ontario. But now for the submissions for sentencing and the sentencing itself, which are scheduled for April of this year, the defense lawyer has said that this judge is off vacationing in Barbados and is going to be in violation of the criminal code if he is going to preside over this case by doing so. Now, as you can imagine, this story has drawn a polarized response about this judge. On the one side, some people are outraged. On the other side, some people are saying, what's the big deal? I would have done the same thing. I think a story like this is a good opportunity to discuss this situation whilst also touching on some important things in our legal system, like the fairness in trials and what is required of judges. Now, just as a disclaimer here, this story only came out a few days ago. The Ontario Court of Justice still hasn't directly confirmed whether this judge is indeed vacationing in Barbados, so let's just speak hypothetically here for the purpose of this video about any judge who is remotely presiding on cases whilst on vacation somewhere outside of Canada. So first off, as the defense lawyer discusses, the criminal code has a part that deals with remote attendance for criminal proceedings. The normal rule is obviously everything has to be in person, but these sections provide an exception and give the judge the power to order audio conference or video conference attendances for the accused, the prosecution, witnesses, jurors, and the judge, him or herself. And the judge can do this if it's appropriate in the situation. So for what's happening in this story, we can look at specifically section 715.26, the remote attendance for a judge section, and what it tells us is that the judge can preside at a proceeding remotely if they consider it necessary, having regard to all the circumstances, including the following: the accused's right to a fair and public hearing, the nature of the witness's anticipated evidence, the nature and seriousness of the offense, and the suitability of the location from where the judge or justice will preside. So to clarify here, the defense lawyer is arguing that it is not appropriate for the judge to use this section to preside on the case remotely because of subsection D, the suitability of the location from where the judge will preside. He is saying that conferencing in from Barbados to an Ontario criminal case is not suitable. Now, obviously, we can assume that the judge is not going to be, by the beach. We can assume even in Barbados, he would conference in from a quiet place with a decent internet connection. But the problem is that he's still not in Canada, and more importantly, he probably left Canada with a vacation as his purpose. So what can we make of it? Keep in mind that this remote attendance exception is a relatively new part of the criminal code, but we can look at some recent cases to better understand how this section has been dealt with in the past. In this case of Patriquin, which also involved deciding on a remote sentencing hearing, the judge decided that she would be presiding the case by video conferencing. And in her justification, the judge said that this was appropriate because, quote, "there should be no concern about the suitability of the location from where I will preside. It is local, private, and equipped for a remote proceeding." So importantly, the judge characterized the fact that where she is video conferencing from is local to the court, which we can assume means in the same city, if not at least still in Ontario. And what that tells us is that being in a local place is part of being in a suitable location for a judge remotely presiding in a case, in addition to, of course, being in a private place and one that is equipped for a remote proceeding. In another case where a judge had to decide on a remote proceeding called the Bartolo, the judge says that the suitability of their location will not be an issue because the judge will be in their courtroom in Prince Rupert. Obviously a suitable location because they are going to be physically in the court that it would have otherwise taken place in. Now, aside from this specific section of the criminal code, let's get into the broader legal system. On Twitter, in response to this story from the Toronto Star, there was a bunch of tweets like this one. Who cares where the judge is? What difference does it make in their ability to decide right or wrong? Does them going to Barbados mean they are a bad judge? These are sensible and fair questions to ask. I'm glad that they asked them. So in response, let me get into why it does matter where the judge is. First off, one perhaps less known aspect of our legal system is that how things look actually matter. There's a famous quote from a British judge that says, "It is not merely of some importance, but of fundamental importance, that justice should not only be done, but be manifestly and undoubtedly seen to be done. Nothing is to be done which creates even a suspicion that there has been an improper interference with the course of justice. So in the legal system, we don't only care about justice, we also care about the appearance of justice. The Supreme Court of Canada has written that a system of justice, if it is to have the respect and confidence of its society, must ensure that trials are fair and that they appear to be fair to the informed and reasonable observer. This is a fundamental goal of the justice system in any free and democratic society. The appearance of justice concerns the effect of the proceedings as they would appear to the average citizen. In the case of Gionnet, which involved an allegation of misconduct by the trial judge, the appellant judge made the following useful points. Judges, like all participants in the justice system, are human beings who bring to the courtroom on a daily basis both strengths and weaknesses that form the human character. Some days judges do not feel well physically, mentally, or emotionally. Some days they are tired, bored, or just plain fed up. Most days, it is hoped, they are filled with enthusiasm, patience, and understanding. But the overarching requirement of all judges is to strictly and ardently disallow all weaknesses, fears, opinions, biases, distractions, or unique personality traits, any influence or role whatsoever in the execution of his or her office. And so you can imagine why it's a problem when we have a judge who is not strictly and ardently preventing distractions in the execution of their office, which may be the case when they have chosen to physically leave Canada and yet continue hearing cases, and perhaps they are also mentally and emotionally on vacation. And so the big issue is that when an average citizen looks at a judge conducting a proceeding like this, it will not undoubtedly seem to them that the accused is getting a fair proceeding. And because of that, the average citizen is not getting the appearance of justice, even if the judge is actually doing a fine job of making the proceeding fair. When an irregularity occurs in a proceeding, severe enough to render the proceeding itself unfair, or to create the appearance of unfairness, then there has been a miscarriage of justice. The reason that the appearance of unfairness is a miscarriage of justice is that it is so serious that it shakes public confidence in the administration of justice. And if there's been a miscarriage of justice, under the criminal code, the accused can apply to an appeals court or the Minister of Justice to get them to order a new trial. Okay, so that's the idea of the appearance of justice mattering. But what about more generally what we expect from judges? For example, I saw a bunch of tweets like this in response to the judge potentially remotely presiding from Barbados. Why does it matter? If a judge or anyone else wants to work remotely from outside of Canada, that's their decision. While I completely get the sentiment of this sort of tweet, the reality is that judges are not like anybody else, so their decisions should by default and design be treated differently. I hate to make this cliche reference to Spider-Man, but it really is a case of with great power comes great responsibility. And this is not like my feelings about it. This idea stems from the unwritten principles of the Constitution, specifically something called judicial independence. Historically, the generally accepted core of the principle of judicial independence has been the complete liberty of individual judges to hear and decide the cases that come before them. No outsider, be it government, pressure group, individual, or even another judge, should interfere in fact or attempt to interfere with the way in which a judge conducts his or her case and makes his or her decision. A judge must be able to properly exercise his or her functions and be able to render a decision without fear of reprisal. And so this is why the requirements of judicial independence include security of tenure, financial security, and institutional independence. So we give judges guarantees that they can keep their jobs, that they will be paid well, and that they can speak and deliver judgments freely. But great power brings great responsibility. Judicial independence is a double-edged sword. While we protect judges from external pressures, they must also maintain high standards of behavior so as to ensure the public's confidence in them and the judiciary as a whole. After all, judicial independence was not created for the benefit of the judges, but for the benefit of the judged, the everyday people of society. That is, the purpose of judicial independence is not to confer on judges a special position of privilege, but rather to ensure that those appearing before Canadian judges can have confidence in the impartiality of those judging them. As the Supreme Court has cited in the past, people appearing before a judge should require virtually irreproachable conduct from anyone performing a judicial function. By the way, irreproachable means exemplary, faultless, outstanding. It will at least demand that they give the appearance of that kind of conduct. They must be and must give the appearance of being an example of impartiality, independence, and integrity. What is demanded of them is something far above what is demanded of their fellow citizens. So the integrity we expect of judges is far above what is demanded of other everyday people. So going back to tweets like this, why does it matter if a judge or anyone else wants to work remotely from outside of Canada? A judge is not like anyone else. We have, on the basis of our Constitution, set aside special protections for judges, financially and legally, for them to do their unique job. And on that basis, we expect them to be an example of impartiality, independence, and importantly in this case, integrity. So everyday Canadians are subject to travel restrictions, telling them to avoid all non-essential travel. And then you have a judge who not only ignores that to go on vacation in the Caribbean, but then also, whilst in a state of vacation, decides they're going to hear and preside over criminal cases that determine whether people will be sent to jail or not? Does that sort of conduct give the appearance of being an example of integrity? You can think about that and decide for yourself. But I wanted to dispel this idea that the remote work considerations of a judge is just like anyone else. It's not, and for good reason. And just to reiterate, none of this video was directed at the conduct of that specific judge because, again, we don't have all the facts and confirmations of this story yet, but it was a useful way to engage in a discussion about the appearance of justice and judicial independence and the requirements we have for judges based on that principle. So I hope you found this interesting. Let me know in the comments what you think about this story. Please make sure to like this video and subscribe if you haven't already. Thanks, and until next time.